Okay, we're back with another part to the presentations that you're making on bankruptcy. I want to share a few thoughts with you on this. First thing I want to talk about a little bit is discharge, and then we'll go on and we'll talk a little bit about exemption. Now, discharge is different for the two different kinds of bankruptcy. First of all, we'll cover this again real quickly. There's a Chapter 7 bankruptcy, which is a complete liquidation. Average person, a mountain of debt due to chronic medical condition. Okay, let's say. That's about average of what I used to see. So what would end up happening is that person would have to actually file bankruptcy, and what they would end up doing is they would file for a complete liquidation. Well, the discharge is opportunity for them to get relief from their actual debts. So when that happened, by the time they filed the bankruptcy, they waited the proper amount of time, they attend the meetings, there's what they call a 341 meeting, cleared up any problems, dealt with the trustee, whatever questions the trustee had, and then after a period of time, if everything is cleared up and ready to roll, then they can file what's called final discharge papers, and the judge will give them a discharge at the end, which means they don't have to pay the bill under any circumstances. Now, the other case is the Chapter 13, and the common term we use for that is what we call the wage earner plan. Now, if people have too many assets, or let's say they have a good job, but they just don't see how over time they'll ever be able to pay all these medical bills, then they in turn can also file a form of bankruptcy, which is called a wage earner plan. Wage earner plan means that something is going to be paid on your debts, and there's a negotiation that goes back and forth. You'll pay on your bills for a period of months, whatever length of time is agreed upon. After you finally pay all the bills, then you do receive a discharge in those cases also. But there's a long, lengthy process in the wage earner plan. Unfortunately, a lot of people have catastrophic problems. It's like they walk around under a rain cloud, and so they get started paying on the wage earner plan. Things don't work out, and so they have to convert to a Chapter 7. We will talk about that later on in the class, but that is another kind of situation. Well, let's move on to exemptions. Like I told you, the only exemptions that are allowed in Indiana is the Indiana form of exemption. This is very important. This is probably 90% of the reason that I'm doing these videos, because it keeps coming up in a lot of my classes. People just cannot understand. They give you a certain kind of a form in best case, but you have to convert that form to fit your circumstances. So basically, exemptions are statutorily defined property that an individual can protect from administration by a bankruptcy estate. This varies from state to state. For example, the difference between Indiana and Florida is amazing. The difference between the federal exemptions and Indiana are amazing. And so it's really, if you're planning to file bankruptcy, it's not probably in your best interest to live in Indiana, but because you're broke, there's no way you can go anywhere else. So it's really very unfair to the debtor in Indiana, because you just do not have very favorable exemption statutes. But the critical point that I'm trying to get off out of this presentation to paralegal students is that it's very important that you file the correct exemptions in Schedule C of the bankruptcy forms. Many, many, many times these are incorrect, and frankly, this can be very problematic. Judges can get pretty upset with the attorney, and down the road somewhere it could actually affect your job if you do not do this one thing correctly. So that's kind of why we're having a number of these sessions, is to, try to stress this thing about the Schedule C and this type of thing. So it's going to take me just a minute, but I've got to switch over to something here. The exemptions are critically important. I cannot say it enough. That the exemption aspect of bankruptcy is very, very important. So hang with me just a second. I've got to switch something up on my computer, and then I'll be ready to get right back with you. So what I want to stress today is that the Indiana Code section, and we're going to put it right up on here. Let me just take out this here. We're talking about exemptions. We're talking about the Indiana Code section. So let me get it up on here. It's Indiana Code, or IC 34-5510-2. Okay, and then there's subparts to this. Okay, so 2, it's A, B, C, and so forth. So the important thing is that one of the things that are going to happen is that over time these statutes may be amended. So if you're viewing this and the statute's been amended, again, this is a disclaimer. You want to double check this. You want to do your own research. So check the Indiana Code. If you're working in Indiana, because the legislature meets, they make changes. By the time it gets approved and becomes effective, it may take me longer than that to make any changes or corrections to the presentation. So always double check. But the starting place here is Indiana Code 34-55-10-2. Okay, so important thing. If you look at item C under that, then you need to look at the real estate section, which is C1. So it would be IC 34-55-10-2 C1. And it talks about real property has a certain amount of an exemption for family residence. So important thing then, exemption for family residence. So what is a family residence? Well, you need to live there, okay? Now, what about if you got your little place at the lakes? Not included, okay? That's not your primary residence, okay? So that's important. The other thing is, and this is something that's subject to constant discussion, for many years the exemption has been $15,000. $15,000, okay? So that's an important number to keep in mind. A debtor can have an exemption in the amount of no more than $15,000. So what if there's two joint debtors then? It says the exemption under this subsection is individually available to joint debtors concerning property held by them as tenants by the entireties. So what does that mean? If it's 50,000 or 15,000, then it would be 30,000 in a joint bankruptcy, joint tenancy. If both parties file bankruptcy, both parties are entitled to a 15,000. Now, like I said before in one of the earlier presentations that I did, you know, in Florida, whatever your house is worth, and if it's paid off, that's exempt. You get to keep your house. So it could be millions of dollars. So take, for example, O.J. Simpson. First advice that he got after he got that judgment against him by the families of the victims in the O.J. trial was move to Florida, buy a house in Florida, because they have the most liberal bankruptcy statutes. Now, all this, always subject to change. So check it all out. But this is something, that you want to consider. So there are other additional exemptions that are available in addition to the 15,000 that I mentioned. There's an additional exemption on other real estate or tangible personal property. So if you do have that lake cottage, then you have an $8,000 exemption on that other house up at the lakes. Or you could take the $8,000 on the house that you own, if you do own it free and clear. Okay, other things, health aids, like for instance, a cane, a hearing aid, all this is exempt. Nobody can take your health aids away. Intangible personal property, which are deposit accounts, cash, and this type thing, $300. Okay, so here again, this is all subject to change, but as you can see, at the time of this posting, you know, these are very low numbers for Indiana. So it's something you want to be very, very careful about when you're taking these exemptions. You know, points are counted off if you do not fill the form out right, because quite frankly, lawyers have to have everything accurate. And quite frankly also, lawyers left on their own are probably a danger to themselves and others. So that's why they have paralegals. So that's why it's important for you to get this right. Somebody's got to get it right, okay? So it's something to be proud of, that you can figure this stuff out. So important that you do this one thing and do it correctly. So that's going to be all we're going to talk about on this section, is the discharge and exemptions, and then we'll come along later with some additional videos on some other interesting topics in the area of bankruptcy. Thanks for watching today.